Hello, welcome to America at its Best. My name is Rebecca Painter and I'll be your host for today's show. Most of our recent shows have focused around the pandemic and the hand you've had in saving lives and getting people safely back to work. Believe it or not, a few weeks ago, it seemed like the coronavirus had relaxed a little bit in South Carolina. My family went swimming at a friend's house. It felt like 2019 again for a little while. Late in the afternoon, my cell phone made this horrible noise. The last time I heard it was when a flood hit and tore up our city. I looked down at my phone to see a text message that said, "Go home immediately, curfew in place until 6 a.m. Monday." I was like, what in the world could this be about? In the hours, days, and weeks that followed that text message, my city and yours saw protests. Some were very violent, some were peaceful. They were all around the senseless killing of George Floyd. Here we are, about 7 weeks later, and people are still seeking answers. It seems like only two solutions are taking over the headlines. One of them says, defund the police. Another keeps this narrative going that Congress will do something about it. This network was built to solve problems facing Americans, and this challenge in this day is no exception. I am pleased to bring you the next hour to show you another way. We'll hear from Executive Vice President of State Policy Network, Tony Woodlief, attorney at Institute for Justice, Patrick Giacomo, and the executive director at the Empire Center in New York, Tim Hofer. They're going to lead us through a conversation about what this network is doing to bring sensible police reform to our country. The kind of reform they're going to be talking about acknowledges two sides of emotions that are running rampant right now. On one side, we have so many police officers who take an oath to protect and serve, and they do it well. On the other, there's a system built up around the police that leads to innocent people getting hurt or killed without any accountability. We will have time for questions at the end, so please use your Q&A box at the bottom of your screen. And to start things off, I'd like to check in with State Policy Network's CEO, Tracy Sharp. Tracy, there you are. Hi. Welcome to the show. Do you want to just share some opening comments before we kick it off?
Sure. Thanks, Rebecca. It's great to be back from the holiday weekend to jump right into this topic. It's an important topic. It gets to the heart of this network's long-term commitment to government accountability and transparency. This is at the core of what helps us take a measured and balanced approach to reform the system and the structure. We need to get at the underlying issues of what creates an environment where government, and that includes law enforcement, can abuse its power over private citizens. So I'm looking forward to hearing some of the ideas, the solutions, the sensible reform ideas to reform the system and the structure at the state and local level.
Okay, thanks, Tracy. Well, with that, let's bring in Tony Woodlief, the Executive Vice President of State Policy Network. Hi, Tony. Welcome.
Hey, Rebecca.
So, Tony, first, give us some perspective on this. Roughly how many law enforcement officers are there in the U.S. and how do you know, are they all, falling into bad ways? How do you know the good from the bad? Give us perspective.
Well, I think, if you look at the professionals who study this, criminologists, criminal justice experts, people who are center-left folks, they'll tell you that the proper language here is not bad apples, but bad barrels, meaning that you have some departments where you've had this kind of system spring up of, a pattern and practice of abuse that's not been checked, and they have to be dealt with department-wide and sometimes city-wide. But they'll also say that, the vast majority of law enforcement officers do their jobs very well. And the challenge is you've got 18,000 different law enforcement agencies across the country, 300,000 law enforcement officers. It's very hard for the federal government to go town by town and check in on everyone.
Okay, so you recently published an op-ed about a bipartisan solution that, according to SPN polling, was highly favorable. The theme was around local control of police departments. Tell us more.
Well, so the argument is, you know, after you had the riots in Los Angeles, after the Rodney King video, which was publicized, and it was clearly an awful thing to watch. And by the way, one of the reasons the video went out was because his brother, the day after he was beaten, went to the local police station and tried to file a complaint. He tried to do the right thing, and the officer on duty wouldn't take his complaint and insinuated that maybe he's a criminal too. And then the video comes out. So when you have this bad local behavior, it has disastrous results, and it invites the feds to come in. So after those riots, the federal government passes a law, because that's what they do, and they authorize the Department of Justice to investigate complaints about local police departments. And since then, there have been dozens of investigations and consent decrees that have tried to clean up police departments, but it's a slow, extremely expensive process. There are reasonable allegations that it's also a politicized process. So depending on who's in the White House, that'll tell you which mayors get scrutinized and which ones don't. And so the argument is that this is really more a proper function of state attorneys general. They sworn an oath to defend their state constitutions. They're accountable to the voters, most of them, and they ought to be looking into these allegations themselves rather than waiting for Washington to come do it.
So tell me a little bit more about these state and local solutions. Natalie Simon is with us today. Natalie, thanks for joining the show. And she submitted a question asking if there are examples of local solutions that have worked.
Well, sure. I mean, California is a great example because you had, after Los Angeles, over a dozen years, the federal government spent in Los Angeles trying to help them clean up their pattern and practice of abuse of citizens. It spent over $100 million. And arguably that things did get better. If you looked at citizen surveys, the number of unarmed civilians killed by police year over year, things got better, but it was incredibly slow and expensive. Now, in Riverside, California, you had this tragic incident where police officers shot a teenage girl sleeping in her car. They hit her with a dozen rounds. They fired about 30 rounds and hit her with a dozen, and they killed her. And so afterwards, the California legislature empowered their attorney general to investigate and deal with the local police department and get them to clean up their act. And so that took 5 years, a lot less money. Police started wearing body cameras. They learned how to de-escalate situations, that kind of thing. And if you look at the chart of citizen complaints in Riverside, and we're talking about surveying people who are not sympathetic to the police, those complaints still went down over a multi-year period. So I think that's an example of where you let the local government and the state authorities deal with it versus Department of Justice.
So Tony, you're recommending attorneys general have control over their police departments. Some viewers might be watching right now, shuddering at the thought of their attorney general, because perhaps the attorney general isn't the one they voted for, taking over the police department. What do you have to say to those folks?
Well, first of all, I wouldn't say it's control. It's just they already have certain powers of subpoena and investigation. They can shine a light on the problem. So it's really asking them to do the job that they swore to do when they took their oath to uphold the U.S. and state constitutions. Now, yes, there are attorneys general, we all know them, who they don't really care about this job. They want to be governor and then senator. But the reality is, look, if we believe in limited government, we believe in we the people, well, at some point we have to hold elected officials accountable. So if I have to choose between an attorney general that maybe I didn't vote for and some bureaucrat at the Department of Justice that I'll never get to vote for, I'd rather have the attorney general, because at least there's a shot at changing him or her out if they're not doing their job.
Well, and you mentioned the Department of Justice and the way the federal government's instituted programs that incentivize bad behavior. Can you give us a few examples of those?
Sure, and I know the other panelists will talk about this, but you've got the 1033 program, which provides military-grade weapons to police departments, the civil asset forfeiture, which allows police to keep property and sell it even when a crime isn't proven. And those programs essentially were ways for the federal government to enlist local police in going after illegal narcotics and immigrants, which I'm not passing judgment on the validity of those goals, but it takes police away from building community relationships and doing all that kind of local policing that we expect when we pay our taxes. So those programs really took them off of their mission and arguably made them much more military-minded than community-minded.
All right. And Tony, what do you have to say to folks who think defunding the police is the best option versus your local idea?
Well, first, I'd like for them to agree on what they mean by it. Until then, I don't feel like we have to speculate on what they mean. I think they're playing fast and loose with that language on purpose, which is irresponsible.
Okay. All right, Tony. We're going to hear from Tony some more at the end of the show with Q&A. So please, again, use the Q&A function at the bottom of the screen, and we'll hear from him in just a few minutes. Tracy, Tracy, you just came back up. I thought that meant you had a question. All right, with that, we are going to turn it over to our friend Patrick Giacomo, who's an attorney with our friends at the Institute for Justice. Patrick, welcome to the show.
Thanks for having me.
We're glad to see you. Now, Patrick, we know IJ does a lot of litigation. Roughly how many cases are you guys litigating around police reform?
So around police reform, we're probably litigating about 15 or 20 cases that somehow touch on this issue. But nationwide, we're litigating about 70 cases against various governments that have overstepped their constitutional limits.
And what kind of cases are you taking on around police reform?
So we work in three areas that are related to police reform. And so as part of those three areas, we're working to end abusive fines and fees, which greatly increases the number of contacts police have to have with regular people. We're looking at ending asset forfeiture, which creates terrible incentives, as Tony mentioned just a moment ago. And then we're also working to end qualified immunity and other special protections that carve exceptions from the Constitution for government officials.
Interesting. So let's start with qualified immunity. I understand you guys have a case that's made it to the Supreme Court. Tell me about that.
Sure. So this case is called Brownback versus King. We represent James King, who in 2014 was a 21-year-old college student walking between two summer jobs when he was approached by two men in plain clothes who started asking him questions. They ultimately pinned him up against a black SUV, and when one of the two men took James's wallet out of his pocket, he believed he was being mugged and tried to run away, which resulted in James being choked unconscious and beaten by the two men. As he screamed for help, passersby called 911 and uniformed officers arrived on the scene. But to James's great surprise and everyone else's who had watched what happened, the officers arrested James and let the two men go because, as it turned out, the two men were a plainclothes police officer and FBI agent who were looking for a fugitive who wasn't James King and had simply misidentified James and then ultimately beat him up. And so after everything happened, instead of apologizing to James for the terrible mistake, police charged James with several felonies. One police officer went around and forced witnesses to delete video of what had happened. And James was actually taken through an entire criminal felony trial by the county in Michigan where this happened. And he was ultimately acquitted on all charges, at which point we filed a civil rights lawsuit against the officers who unconstitutionally stopped, searched, beat, and arrested him. And when that case went to the court, before the government even filed an answer, they filed what's called a motion to dismiss or for summary judgment. And they said that the officers, regardless of whether they violated James's constitutional rights, were entitled to something called qualified immunity, which is a doctrine that the US Supreme Court created in 1982 that operates as a default exception to the Constitution, where a government official who violates your constitutional rights is exempt from any accountability or liability unless you can show that there is an earlier case by a court in your jurisdiction with the same specific facts holding that what the officers did, and this doesn't just apply to police, but any
that applies to everybody?
Correct.
Any elected official? Wow.
Right. We see it a lot with police because police interact with people more so than most other government officials. But this doctrine operates as a default exception to the Constitution unless you can point to an earlier case where exactly what happened to you and a court said it was unconstitutional. And so in our case, the district court said you can't find cases in your jurisdiction that show exactly what happened here was unconstitutional, so the officers are entitled to immunity and threw the case out. Now, we appealed that decision to the Sixth Circuit U.S. Court of Appeals, and in a miraculous ruling, the Sixth Circuit reversed that decision and said the government wasn't entitled to qualified immunity because what the officers had done was a violation of clearly established constitutional rules. But the case isn't over now, and it's in the U.S. Supreme Court, because even after we were able to, 6 years later, defeat qualified immunity, the federal government is now asking the Supreme Court to carve out another special protection for government officials that would shield them from actually having to justify what they did under the Constitution.
Wow. So help me understand this part. On the surface, it sounds like qualified immunity is a really bad thing, especially with the case you guys are working. On the other hand, some of us have friends that are police officers in some of the most dangerous parts of the country that would give you nightmares if you heard those stories. And you can only hope that qualified immunity is intended to allow these police officers to do their jobs and put these really scary people away. So if qualified immunity goes away, what's going to protect people like, my best friend who's a police officer in Atlanta?
So one of the perverse things about qualified immunity is it is this completely judge-created doctrine that sits above the Constitution. If we actually allowed police and other government officials to defend their claims under the Constitution, police are already protected under the Fourth Amendment, which only prohibits them from using unreasonable force or undertaking unreasonable searches or seizures. So every case that actually gets to the merits of the constitutional question is already going to look at the circumstances from the perspective of the officer and decide whether they acted reasonably. So in short, the Constitution doesn't require police to act perfectly, and nobody thinks that they should. It just requires police to act reasonably. And because of this doctrine of qualified immunity, courts don't even address that issue in many cases.
Reasonably. That's a great quote. Thank you. So what's the timing? When do you think we'll hear the outcome of this case?
So we will have all the briefings submitted in September, and the court will hear the case at some point next term in a frustratingly vague time frame of probably between October and February. And then we should have a decision sometime by next July or so. But the court kind of does what it wants to do, and we're at its mercy. So we'll see what the court's going to do with that case. But I should point out that the Supreme Court recently declined to address the issue of qualified immunity in a number of cases it had been holding. And this case does not have qualified immunity at issue. So this case won't determine the outcome of qualified immunity, but what it will determine is whether the government will be given yet another special protection that allows its agents to violate the Constitution without accountability.
Got it. Okay. Now let's move back to the beginning where you mentioned you guys are working to end abusive fees and fines. What does that really mean?
So we call this taxation by citation. And what you see is in a lot of states and localities across the country, rather than raise taxes to meet their operational revenue requirements, what cities are doing is they're fining people for all sorts of petty and silly things to get up their revenue. And so, for example, we're litigating a case in Doraville, Georgia right now, which is in the outskirts of Atlanta, where the city gets about a quarter of all of its revenue from fines and fees. And the way that it accomplishes this is, one, by running a speed trap that brings in millions of dollars every year based on speeding tickets. But two, and more perniciously than that even, is by citing people for petty things like cracks in their driveway or having a wood pile in their backyard. And when it does these things, it's not just citing them and having them pay a fee. It's actually charging people with misdemeanors for these things, which cause them to pay money to courts, which then makes up a large portion of the city's operational funds. But it's also ending up with people having criminal convictions on their records and being on probation because, like I said, they have a crack in their driveway or a wood pile in their backyard. And so the way that this ties in with policing is that this type of using residents as ATMs causes police to interact with more people more frequently and creates tension a lot more often than it otherwise would be if governments were actually just, protecting health and safety, which is what they're supposed to be doing. And so it puts police in much more dangerous situations more frequently, which inevitably, as just a matter of averages, will cause them to have to make tough decisions more frequently than they should be.
Is it true? A story came across my desk recently that I think was from Institute for Justice that you guys are representing someone who's been charged more than $30,000 in fees and fines because he didn't mow his yard. Is
Yeah,
that?
that's a case in Dunedin, Florida, where a man who was gone taking care of his late mother's affairs had the guy who was mowing his yard actually die without him knowing. And the city of Dunedin, Florida started charging him, unbeknownst to him, $500 a day because his grass was too long, to the point where he had racked up $30,000 and the city tried to foreclose on his house. And so you see these kind of things in too many examples to list all across the country, where local governments just see dollar signs when somebody is in their jurisdiction.
Yeah. Okay. Well, let's go through your last piece here, and it's all about ending what I think you call legalized theft by police. What's the story there?
That's right. So this is civil forfeiture, which is the doctrine that allows police on just bare suspicion to confiscate money or property that they think, again, based on suspicion, is tied to a crime in one way or another. It doesn't require them to charge anyone with a crime, and it doesn't require them to convict anyone with a crime. So this is, in essence, policing for profit. And there are a lot of police agencies across the country that get an enormous amount of money from these forfeiture funds that they take, which creates a terrible conflict of interest and screws up all the incentives, but also creates this bizarre loop where the police are paid for by money they take, which justifies them taking money in the first place. And you kind of are left to scratch your head. And so one of the cases that we're currently litigating involved a woman who was visiting her elderly father in Pittsburgh from Massachusetts. And on Saturday afternoon, he gave her a large amount of cash that he had squirreled away in the house because she took care of his finances. And she was trying to travel back to Massachusetts to put the money in a bank so that they could buy this man new dentures and other things like that. When the TSA saw the money in her bag, though, they flagged down a DEA agent who ultimately decided it was suspicious that this woman had all this cash and confiscated the money. She was never charged with the crime. And when you wonder, well, maybe they just do this to bad people, or maybe they have a really good reason for taking it. In most of the cases that IJ has gotten involved with involving civil forfeiture, once we sue the government, they give the money back. And so in this case, which is still going on because it's a class action lawsuit against the TSA and DEA, they already gave the money back. So it beggars belief to think that they had a real good reason to take the money other than they wanted to buy stuff with the money that they could take away. And so that's why we call this legalized theft, because it doesn't bring in normal standards of due process. It doesn't require the government to prove anything. It just takes the money and then asks you to prove why you should get it back.
Okay. And last question, I want to end where we started with qualified immunity. Debbie Gatte asked a great question. Given how much qualified immunity is being discussed, can you give us your thoughts on why the Supreme Court passed on the recent cases?
It's obviously an enormous amount of tea leaf reading as far as why they did. We do know that Justice Thomas was apparently the one behind collecting all these cases over the last year because he wrote a dissent in one of the cases. In fact, that's a great case that it shows you how silly this doctrine is, because that case involved a situation where a suspect was bit by a dog, and he pointed to a case where another suspect had been bitten and said, see, it's unconstitutional. And the Sixth Circuit said, actually, in that case, the suspect was lying on the ground. In your case, you were sitting on the ground with your hands up. And so that wasn't close enough for us, and the officers are entitled to qualified immunity. But as far as why the court doesn't wade into the issue, it might be because it's such a hot button issue. It might also have to do with the fact that stare decisis principles that would be implicated by overturning a case from 1981 would also implicate stare decisis decisions for other contentious Supreme Court decisions from that era, for instance, Roe versus Wade. And so there could be those sort of procedural reasons why the court doesn't want to take up this issue. But all of that is pretty much guesswork, unfortunately.
Okay. All right. Thank you, Patrick. If you've got questions for Patrick, please add them to the growing list of questions in our Q&A queue, and we will get to him again towards the end of the show. We're now going to move on to Tim Hofer. Tim is the executive director of the Empire Center in New York, and he's a key leader in this country around government union reform. Tim, welcome to the show.
Thanks for having me.
Tim, tell me, what do police unions have to do with police reform?
Everything is the short answer. You know, we are where we are because of two things. I think first is that states have civil service laws that include discipline rules. And second, often states will let their unions put additional rules in their contracts through the collective bargaining process. These two factors have affected every police department differently, at least in New York, because each contract has its own rules.
What kind of rules are they putting in? Can you give me some examples of rules that you think are egregious?
Yeah, I mean, the rules, they're all over the place. There was an article in the Journal this morning that went over some of these. Some New York specific examples include taking away a mayor's power to fire a police officer or to suspend an employee without pay. In Minneapolis, the police chief noted last month, I'm just looking for this quote, directly he said, "There is nothing more debilitating to a chief than when you have grounds to terminate an officer for misconduct and you're dealing with a third-party mechanism that not only allows for the employee to be back in your department, but to be patrolling in your communities." I mean, and again, it's all over the place, right? There are things like 48-hour cool down periods when there's an incident, especially involving police officers or emergency personnel. There's a cool down period before supervisors can even talk to their employees about the incident. Collective bargaining agreements will often impose maximum penalties. There's a town on Long Island where if you are caught injecting heroin into your own body, the most that they can do is give you a warning, verbal or written. It doesn't really matter. And then it goes to things like how do you collect evidence in these proceedings, and so they'll put procedural reasons that will prevent the evidence from being included during a disciplinary proceeding because you haven't hit a timeline or a mark or something to that effect.
Okay, so what about recently, I think most of us saw on the news, the fellow in Buffalo getting knocked down by police officers. What was in that collective bargaining agreement?
Well, that was a really interesting example. So one of the things that we talk about in collective bargaining reform, specifically in New York, but I think in a lot of states, is that they negotiate these rules. And so part of the rules of collective bargaining here are that the terms of a collective bargaining agreement are not subject to public review before they are passed and signed by the employer and by the union. So they negotiate these contracts in secret, they pass them, and then ultimately the taxpayer, the people who are on the hook for paying for them, don't get a chance to see them or weigh in on them. So when these two police officers knocked this man over in Buffalo, and the media went to look at, well, what's going to happen to these officers, they couldn't determine it because they couldn't get their hands on the contract. They had to go to the union and ask them to give them a copy.
Wow. All right, so what can we do about this? What's Empire doing about this?
I think there's a few things that we can do about it. And if you look to what has happened already, we've had the courts here that have done actually a fairly good job of recognizing that this has gone too far, both through civil service laws and in the collective bargaining process. And the courts have done several rulings that have prevented the unions from being able to negotiate on disciplinary proceedings. So one of the things is more of that. Continue to ask for more of these cases to be filed, for folks like Empire Center and others to come along with amicus to say that this is really important, that we need to remove the disciplinary process from collective bargaining. If you take that out, then it's the employers who then become accountable for the actions of their employees. And then we've got a chain of command. You've got something you can look down, we can see what happens, and we can go from A to Z. Some of the other thing, there are three specific things we're talking about. One, arguably the most important, is for us to better understand what this process is. So we need to know what the rules for making the rules are.
And they're different in every state and every police department?
For literally in every single police department in every single state. So the state think tanks, I think, have an opportunity here they have a unique role to be able to go in and look at what's happening in their states, determine how the rules got to where they are, and then to begin to ask those questions. We'll be putting out a paper later this week that does exactly that. It just tears apart the collective bargaining process and the civil service laws, and then asks the questions. What does it take to bring a disciplinary case? Who can bring it? What are the rules behind it? What are the timelines? How much does it cost? All those kinds of things. And if we get a better idea of how this system works, then we can start asking the intelligent questions of, well, how do we fix it? How do we make it more fair? How do we deal with some of these inefficiencies and inequities that we see happening more pronounced in the last weeks than they have been before that? I already talked about collective bargaining. Making that process more transparent would be huge. Often, especially in the union-heavy states like New York and California and Illinois, you're negotiating these rules for how to do discipline, for how to create these rules for what employers can and can't do to their employees through the collective bargaining agreements. So if we had a chance as taxpayers, as folks at the Empire Center, as anybody, to inspect those before they're signed, before they're passed, and to weigh in on them, then some of these things inevitably will not get through and be more of a public process. And then I think the last thing that we might want to look at there is binding arbitration. In the states that allow binding arbitration, some more heavily than others, it becomes, if nothing else, a financial disincentive for employers because it costs gobs of money. I mean, think hundreds of thousands of dollars for an employer to bring an employee through binding arbitration. So it's often cheaper and quicker and faster and less painful for the employer to reach a settlement with their employee rather than try to terminate them for cause or to punish them for cause. Then you end up with this inherent problems in the system where you've got bad people doing bad things on the taxpayer's dime.
Gotcha. Okay, last question for you, Tim. Now, SPN polling has shown that when people want to leave their unions, one of the biggest factors stopping them is there isn't an alternative to the union. And as I mentioned earlier, I've got a few close friends who are police officers and are interested in leaving for a lot of the reasons that you just mentioned, but they don't have anywhere to go. Empire is also doing something about that. Tell us about it.
Yeah, so New York's one of the states. Empire Center is one of the groups that's working on this in this post-Janus world, helping folks choose to leave their union or at least know about their option to do so. What we've heard overwhelmingly over the last 2 years is we need an alternative. We need something for when we leave the union. And whether it's perceived or not, it's real. They tell us this, they tell it to us every single day. I'm nervous that if I leave the union, I'm not going to have legal representation or, I'm going to miss my benefits or whatever. So we're going to start an organization that does just that. It'll do it at a fraction of the cost of what the unions are doing. And most importantly, it'll do it without the policy and political baggage that the unions bring. It's not going to be a lobbyist. It's not going to support political candidates. It's going to answer the very specific 3 things that they're asking us for and give it to them as an alternative.
Okay, thank you, Tim. All right, now let's bring all of our speakers back and move into the Q&A section. We'll do our best to get through all of the questions, and if we miss a question that you asked, we will give you a call after the show and make sure that they're addressed. Okay, welcome back, everyone, and if you haven't asked your question, please go ahead and get it in the Q&A queue. Okay, let's start with our friend Ed DeVilbiss. Ed, welcome back to the show. So glad you're here. Ed's question, can SPN and the state think tanks do anything to keep Washington from getting involved in our city's riots? I think part of what Tony said about attorneys generals plays into that, but do you guys have anything to add?
Well, I can, yes, getting attorneys general involved, but the broader theme is we should expect our elected officials at the state and local level to do their jobs. We see too much shirking. When you look, for example, at how governors in different states either cram COVID positive elderly back into nursing homes or don't let COVID negative married people in nursing homes be together. They all blame the federal government and say, well, the feds are making me do this, which is patently untrue. But they don't want responsibility. And I think a lot of them don't want responsibility for dealing with disorder in their streets. They'd rather have the National Guard or the federal government come in and clean it up for them so they can have clean hands. And it's an abrogation of duty.
Okay. Next question, Patrick, I'll put this one over to you. This is from our friend Ed Johnson. Ed, welcome back to the show. Patrick, how do you recommend and advocate law and order policy reforms that fully recognize that all men are created equal and that they are endowed with certain inalienable rights?
Well, I certainly think that one of the keys to doing that is simply to allow courts to enforce the Constitution as a limit on the government. And the Constitution itself, through the Bill of Rights and the 14th Amendment, ensures that those promises of the Declaration of Independence are enforced against the government, which was the evil at which the Declaration of Independence was aimed.
Okay. Anybody have anything to add? I think that says it all. Just want to make sure. Okay. Next question. Tony, this is also from Natalie Simon. Who are the law enforcement champions?
Well, if you mean people who are on the side of law enforcement, I would say I can speak for myself and a lot of the other people who want reform. I mean, I've got family and friends who are in law enforcement. It's a thankless job. It's a low-paid job. It's the 16th most dangerous job in the US if you look at fatalities. That data includes like the lady at my local sheriff's department who takes phone calls. So when you isolate officers on the front lines, the fatality rate is much higher. You look at Texas Highway Patrol, for example, they got 3,000 active law enforcement officers, and they've already got 116 fatalities in the line of duty this year, 27 of them by gunshot. So all these people I know who are good police officers, they're the ones who really despise incompetent law enforcement. And so I think that any of us who want to fix the system so that the competent people can rise and we eliminate the incompetent and weak is on the side of law enforcement.
I would just add, reiterate Tony's point about how this is best addressed at the state and local level, and that even though it's a difficult issue, it's a pressing issue, and we can't allow state and local officials to shirk their responsibility to get at the heart of this problem.
Tracy and Tony, you both mentioned the phrase shirk their responsibility. So you basically are talking about the blame game. Everybody's blaming each other. No one's just stepping up and doing the right thing.
Well, I'll give you an example from my state of North Carolina. Our governor recently told George Floyd's sister that he is going to work for justice in her brother's name. He was our attorney general for 16 years. And on his watch, there were repeated allegations of racism and discrimination by the Alamance County Sheriff's Department. They were pulling over Latinos at twice the rate of other drivers and arresting them. He never did a thing about that. And so the Department of Justice had to come down and investigate. It was expensive, it was politically motivated. I'm not saying he should have found that they were wrong, but he didn't bother to look. And now he says, well, I'm gonna work for justice. Well, he had a chance to work for justice, but it was gonna be messy and might hurt him politically, so he chose not to. That's what I mean by shirking.
Yeah, I think it's partly the blame game, partly just punting when it is politically difficult to address tough issues, and that these issues exist at the state and local level. It's better to have them addressed by those who have a vested interest, who live there, and not necessarily punt immediately to the DOJ or to the courts. And in some cases, right, that's appropriate, but where the responsibility has been clearly laid out constitutionally, those leaders need to step up.
And I would just add procedurally to that, we are where we are because of what the unions have done. And it's really easy to say police and their unions are the bad guys, but they are empowered only by the state and local governments that give them the authority to do so. So those governments are approving these contracts or putting them in a position to allow these things to happen. And ultimately it lays with them to change that. That's where that power, I'm just backing up to what Tracy said, that backing that power in, it goes directly to those people.
Thank you. And another question from Natalie Simon. And Natalie, before I ask your question, I do want to remind everyone, since we only have a limited time for the show, we only featured a few of the experts out in the field, but I do know that there's a lot of interest across the think tank community on this issue. We had a internal webinar for the think tanks to talk about different solutions in their states, and over 200 people signed up for it. So if we can't answer your question with this group, we will make sure we get to the right think tank who knows a little bit more and give you more info. So Natalie, your question is, has anyone here heard of the EPIC program? Ethical Policing is Courageous. The New Orleans Police Department created it and implemented it. Georgetown Law School started a program based on the model. It seems to be working well and a good program to leverage. Any of you guys familiar with that in your states?
I haven't heard of that program. I'm familiar with, there's something that sounds similar that works on de-escalation and trying to humanize the people you work with and kind of have a mental illness education so you recognize those signs. But I haven't heard of this particular program. I know there are several initiatives like that to try to give law enforcement officers some of the additional training that they don't get in the academy so they can deal with this complex set of human relationships that are just thrown out in the streets and expected to clean up on a daily basis.
Yeah, thanks, Tony. And Natalie also mentioned that New Orleans has been under constant decree. It's seen tremendous improvement in constitutional policing and pretty quickly. In some ways, it's the poster child for constitutional policing. I know our friend Daniel Erst-Palmer, who's head of the Pelican Institute in Louisiana, probably has a lot to say about that as well. So we'll make sure we connect with him and keep him a part of the conversation. So thanks, Natalie. All right. Got another question that just came in. Debe Gate, given all of the calls for police reform, is there more appetite for police union reform compared to other pockets of labor reform? Tim, sending that one your way.
One of the things that's been most surprising as we've moved into the space of labor reform and studying the impact and power of unions has been how the police have responded, both going back a year and then going back a few months. Something interesting that happened to us recently, the city of Albany, where state government is seated in New York, has obviously a city police department. Over 80% of the police officers opted out of their union recently, for which we take a little bit of credit, but not all of it, because a few things happened. One, they were unhappy with the service they were getting from the PBA. They felt like they weren't properly represented, some of the things I talked about earlier, but also because they were non-responsive both to the city and both to the needs of the officers. And so when push came to shove and they felt like they weren't getting what they wanted, it was actually a very easy decision for them to leave the union. Now, they started a local association. We could debate whether that's good or bad probably all day, but that's a different call. But so, yeah, I think that there's more willingness to look at this. The fact that this conversation is happening is different than it probably would have been 4 months ago, both among the populations of people we know, but also being able to have these conversations, me to a police union, where they're willing to listen and they're ready to hear the other side and maybe broaden a little bit the scope of what they're thinking about.
Thanks, Tim. Okay, Patrick, this question's from you, from Ryan Haney. What do you think about state level 1983 actions that don't allow for qualified immunity protection, like what's been done in Colorado?
Yeah, I think there are a lot of interesting state level workarounds that are being floated out there. The one in Colorado is, I think, a good attempt at doing that. Another thing that state governments could do is essentially just waive their state and municipal protections and say, when an officer violates your constitutional rights and the city that we represent's name is on their badge, we'll stand behind that decision and the buck stops with us. But I think this is a great area for the laboratories of the states to wade into. And one of the frustrating things about qualified immunity is that it was a doctrine that the Supreme Court just decreed, which overnight applied to every type of government official at every level. And so it was the opposite of this sort of state and local federalism thing. It was just one day there was no protection, and the next day there was this extremely strong protection that applied to every single state, local, and federal government official who violates the Constitution. So I definitely think things like what Colorado is trying and what other states are at least discussing right now would be useful. But I do think, and I know we're talking about police reform, but the thing to keep in mind is that these doctrines apply to all government officials and not just police. And the Constitution does the same, and we should keep that in mind as we move forward.
Okay. All right. So any final thoughts from our panelists as we wrap up? Tim, I'll start with you.
We really saw an opportunity to change the tone and tenor and our place in this conversation when this all started to happen. And I don't mean that in an opportunistic way, but rather there's a legitimate role for the state think tanks to play here, for us to be able to provide some context that doesn't exist. And so we're excited to be able to be a part of it. I'm excited that there's some, excitement from the donors and from SPN and from the communities to do that. And hopefully we can just use that to move some of these things forward, both in places we care about, but also to provide better services.
Great. Thank you. Patrick, final thoughts?
Sure. I think that if citizens have to follow the law, the government has to follow the Constitution. And I think 2 points that Tim and Tony have both made, that, you know, a lot of people who interact with police are interacting with state and local police, not federal police. And so the answers could lie very heavily in the state and local realm. And, you know, we just need to look at the incentives we've set up and what we're asking police to do and whether those things line up with good constitutional policing or not. And keep in mind that this isn't a pro or anti-police position. It's just a general accountability position that good police should support, because this will help the public trust police again.
Great. Tony, any final thoughts from you?
You know, one of the key things for SPN is we try to support and build up think tanks to have an influence on state policy and restore the balance of federalism in this country. And this issue, to me, is just, it's central to that. If our state officials don't start doing their jobs and protecting their citizens, we're going to have the federal government come in and do it. And it'll be another example of the feds trying to tell everybody in the country how to live and not doing it well.
All right. And Tracy, want to close this out?
Well, I just want to thank all of our speakers. They spoke about an urgency, and I think Tim especially mentioned that there's a window of opportunity we have right now to make these changes in the system, really sensible reforms, to strengthen the levers of accountability so that we could restore confidence and trust in our law enforcement to protect all Americans. So I'm grateful for just the constitutional insights, the specific insights at the state and local level, and the examples we have out there of things we can try and reforms that could be put in place. But the point is that now is the time for action. Now is the time to move forward, for our elected officials to be given the tools and the ideas to step forward and make these reforms really to protect all Americans. So I'm grateful for our speakers and their time today to address this issue.
Thanks, Tracy, and thanks to all of you who joined us today. I do want to let you guys know, I mean, there's so much we could cover here. There's 64 think tanks across all 50 states, many of which are working on this issue. So if you want to be a part of the conversation and come to the table, please shoot Tracy an email and let her know so that we can bring you in on these conversations now and keep you updated on this important work, because we're just scratching the surface with our 3 guests we've got on the show today. I'd also like to encourage you to tune in same time on Wednesday, July 22nd. We're going to have a special episode of America at its Best, and it's all going to be around the idea of conservative fusionism. If you have no idea what that means, and I'm sure many of you do because you're a lot smarter than me, but if you don't, tune in. I promise you it'll be fun, a little philosophical, a little bit of tap dancing, but at the end of the day, we'll be talking about the future of what has been this movement in past years. So hope to see you there, and thank you so much for joining us for this serious topic today, and we'll talk with you more about it soon. Have a good week.
Thanks, everyone. Take care.